Any mentioning? Yes.
From supplementary list, item number 1.
Yes.
Delay of 1
Yes.
These to condone ready to condone the decision as party.
Well, the order of the learned stage, well, the order of the division bench.
Logic. This is the main feature that is page 52. Unacceptable.
Yes.
We are looking in the participant. Yes, it's also indicated that the person who is agreed they can go to the same forum. Now, what happened in this case? Because the participant, may I take it to page 54, page 54,
Yes.
participant of the judgment. May I just read it also? It is the cardiac principle applicable in all cases without exception that party consenting to other cannot be a party agreed by such order to be entitled to prepare an appeal. Therefore,
So, where is the erroneous findings, sir, for us to interpret?
I'm here only with a limited trend that the petitioner may be just allowed to file the review petition before the same forum in the EM court, because the orders that from the EM, that is the Garvey's Authority Council, has passed an order stating that there was a consensus order. Actually, what happened due to some
You want to file a review there?
lordship,
The very same forum.
lordship, in the same forum, the EM.
What is the madam?
Yes.
Is there any objection?
No, Your Lordship.
There's no objection.
For the,
Not for the delay, but on the merits.
on the merits, Your Lordship, as of now, I don't have the instruction because, like, my.
Madam, when you come here, you have to
Yes,
come prepared.
yes, Your Lordship. I have no objection, Your Lordship.
You can't say I have come prepared for surgery, not for switch off there after surgery. Then the patient will die. See, we will condemn the delay.
Yes, Your Lordship.
With regard to on merits, he says the division bench has passed an order to find an appeal before a different forum. But he wants to go and find an
Lordship,
appeal for the same
o-
forum.
only that one.
What is the prejudice it will be caused?
Yes, Your Lordship.
She has no objection.
But how can we interfere when the power of review is very limited? Scope is very limited. That is the erroneous finding.
Yes, no, Lordship, my only contention is I'm not saying there is a erroneous, because even in that due to due to some mistake that actually the previous counsel who has been taking up this matter as per this order, they supposed to go and file the review before the same court, because the case was started in the EM court. The order of the EM says that there was a consensus order. Instead of filing the review, they have appealed that against that order, against the order of that EM. They filed before the CEM. CEM has set aside the order.
No error apparent of his.
Lordship,
Get it corrected in the Supreme Court.
no, Lordship, my only humble prayer is, since we are not challenging this organ, I'm not saying regarding erroneous.
The order. In the review, you have to question the order and place in terms of order 47.1, the order is erroneous and that the review is permissible. You say that there is no error in the order. You want to modify the order. How is it permissible in review?
No, erroneous, because here actually at that time of argument I said that we may be allowed allowed to file the petition before the. There is a 193 days, Lordship.
since we find that there are no merits in the review petition, and that the respondent has also no objection for the
193 days.
delay being controlled, or delay is controlled, registry is directed to number the review petition, number it and pass based on the judgment of Supreme Court. The review is not made, giving the order. The registry number the appeal, review petition, give it to me. Sorry, you take it down before the Supreme Court.
Most praise Lord.
Yes. Sir, give him the entire that review order. No, it has got to be numbered. No, delay condo. Then number it, let them send it. That is the procedure. How can we pass an order on merits in condone delay petition?
We condone the delay and then we.
Condone the no, it's not correct. Delay has got to be condoned,
Yes.
and it has got to be numbered.
Yes. No, that's it.
Ask them to number it and send it.
Yes.
Let the supplementary list be also be printed. Then in the supplementary list, review can be disposed of. Yes. Yes, a supplement. Give that order. And as I could say, the entire thing we can incorporate. Anacha. Manas, கைது போடலையா? Orders come. Yes.
Supplementary list for pronouncement of order.
Who is appearing with the? You are
Yeah, my lord,
For the
I am for the
instruction, for
petitioner,
the
my lord.
Writ petitioner.
Yes, my lord.
Yes. You are from Union of
For the
India.
respondent.
When the correction in the eyesight by means of LASIK surgery is permissible to doctors in terms of the guidelines, it is highly ridiculous that such an exemption is refused to softeners. Though it has been argued on the side of the respondents that yardsticks are prescribed even for barber, cooks, etc., as per various tables, this court concerned with the applicability of yardstick to the nurse alone on par with the doctor. The main role of a staff nurse is to assist the doctor and attend the medical requirement of the patient. In my view, clause number 67 should be made applicable to doctors only, as they, in the midst of performing the surgery to the patient, affect the vision problems caused by refractive errors. Then the life of the patient would be at stake. In the past, we come across several instances about a wrong side surgery performed by doctors in the medical history, which include performance surgery in the wrong body, wrong side of the body, wrong patient, etc. When concession is given to a doctor, treating a staff nurse with dissimilar yardstick cannot be acceptable. Then, from the foregoing discussion, the court is inclined to pass the following orders in the writ petition. Clause number 67 being discriminatory, arbitrary and violative of 14 of the Constitution of India is interfered with. The direction is issued to the respondent to include both doctors and nurses in the guidelines, but column to be eligible for appointment, even if they have undergone LASIK surgery. To that extent, the guidelines are quashed. Since 6 years have gone by, the petitioner shall undergo another medical examination, and if found suitable, she shall be accommodated in the existing vacancy or the next vacancy that may arise. It is made clear that without appointing the petitioner as a staff nurse, if medically fit other than LASIK surgery, no other staff shall be appointed. Post off.
My lord. Deeply of your lordship.
Highly obliged.
Sign it in other pen. One more case is there.
Two more. Two more cases.
Two more cases.
From the daily list,
Highly obliged,
item number 1.
My lord, I have given a copy of list of dates for convenience, my lord. I have submitted a copy of the list of dates, my lord, for convenience.
What is the matter about?
My lord, the petitioner herein, my lord, he was working as a senior instructor at Shillong Polytechnic.
We'll take it next week.
My lord.
Next week. Check the. Yes.
Well, obliged. Obliged, my lord.
Item number 2.
My lord, this is
Matter
the
found letter counsel to the respondent 4 to 8 are found absent. Who is appearing with the respondents? 4 to 8.
Your Lordship, 4 to 8, Your Lordship, in 6 is the Union of India, and rest of the are the private respondent, Your Lordship.
Yes.
So they didn't give till date the Galatnama to me, the handover to me the brief on behalf of the respondent. But as a
When the notice has been served,
Your Lordship, they filed this earlier, this affidavit in this case.
they filed.
4, 5, 7, and 8. They
Ah.
filed the affidavit also, Your Lordship. So when this
What about 6?
6 is the Union of India. Union is not necessary party, but I cannot accept the brief because as a Central Government Council, only respondent 6 I can appear.
6 is an independent body.
The 6 is the Union of India, Your Lordship.
Well,
6 is the Union of India.
the lady was here for the previous case.
So, Your Lordship, Union of India I can represent, but others I cannot represent without any authority.
See, last time when the matter came up before Justice Ding Dog, whenever the counsel for the respondent 4 to 8 found absent, accordingly, so and so, whenever the petition submitted, this matter will be adjourned. We heard on the next day. Submission will be adjourned. This is a matter after 1 week.
Yes.
Ask the counsel, see, how can a counsel representing Union of India can be absent? But is there any proof to show that other respondents have been served?
Well, earlier occasion, my lord, the CGC continued to appear, and subsequently, my lord, the learned friend, he appeared and claiming that he is appearing for the case.
What is the issue involved in this writ petition, sir?
My lord, with regard to the, my lord, after prolonged service, in 2003, the management served a notice that your service would be reduced to contractual appointment. So because of that, we came before this honorable court.
So you have been directly appointed and they may convert it into a contractual appointment.
My lord, my
Recently we passed an order, that's saying that, I think last week we passed an order saying that the contract, Food Corporation of India case and all will be quoted. Oh, so open court order. Take up the judgment.
I will look into.
Sir, when you have employ a person directly, how can you convert into a contract employee and then as a outsourcing employee? Where is Union of India? You
I'm for the Union of India, Your Lordship.
are appealing for Union of India.
Yes, I'm just as a government counsel.
Repeatedly I've been asking who is
He
representing who
asked
is
for the management authority.
So here, Your Lordship, Union of India does not have any control about that.
One minute. First, I'll take the prayer and the affidavit. Here, the problem is the cost title is very short, and we are not able to note who are all the parties here. Where is the full cost title, sir?
My lord, in the writ petition, my lord, can you come to page number 3?
Page number
Page number 3 of my writ petition.
3.
My lord. 3 writ petitioners are there. And
One
number
minute.
1 to...
No, 1 minute. Page number 3.
Yes, ma'am. Respondent 1 to 3 are the state government. They are granting aid to the schools.
This one. Yes.
But 1 to 3 are the state government.
You are appealing for
Your Lordship, I can appear only for respondent number 6.
respondent number
6.
3,
6.
5,
6.
6.
Yes.
Yes.
Union of India.
Who is appealing for respondent 1 to
But
3?
1 to 3
1
is
to
the
3 is
state
state
government.
State government, Your Lordship.
Who is there? Who is there? Nobody is there.
Very unfortunately, throughout earlier they appear. Only today they are not appearing.
And the matter is called, there is no representation on behalf of respondent 1 to 3. Respondent 1 to 3 are expected to appear virtually in the next date of hearing, as there is no representation on their behalf before the court. Who is appearing? 4 has not been served.
But they filed the affidavit. But as I said, Madam, he was appearing for Paul Union up in the school management. And he filed the affidavit for respondent for 4, 5,
You are appearing for
7, and 8.
5. You said you are appearing for 6. Who is appearing for 4, 5, 7, and 8?
Your Lordship, when this brief is handed over to me, Your Lordship, and after that I find that managing committee of Hillview Secondary School is a private person, Your Lordship.
So you can't appear.
So I cannot appear as a central government council, Your Lordship.
Yes.
So this is my plea, Your Lordship. And then
Now you'll have to send fresh notice.
I can take a fresh
So
notice.
it is represented by the council appearing for the 6th respondent that even though notice has been taken on behalf of the 4th respondent, he cannot appear but represent the 4th respondent. The petitioner is expected to take fresh notice, private notice to the 4th respondent. Who is appearing? 5?
4, 5, 7, and 8, Your Lordship, I cannot
You
appear.
already taken notice.
Earlier, my predecessor.
The predecessor took notice.
Yes.
You means somebody on behalf of the, yes. So fresh notice, so you make it as 4, 5, 7, and 8. Returnable by, give some date, madam, name, month of April, 2nd or 3rd week. After 11th. 16th, 17th, how is it? 17th. 17th. See, 2019 matter is pending. Nearly 5 years have gone by.
But
For service of notice, it cannot be pending for the, most of when cases are very minimal here.
and the petitioners are retiring.
The reason why I am sitting singly is that to clear all the old matters. Clear means not physically clearing. If you have a good case, I'll pass appropriate order on merits. If no case, then we can close it. Then tomorrow he will come and say that the change of address. Then the paper publication. By the time my tenure will be over.
Your Lordship, in this case, basically, Your Lordship, the earlier Central Government Council appeared, but it is not the proper procedure, Your Lordship. Because when this we are attending on behalf of the Union of India, then we should not represent the private party as a Union of India. It is not correct position.
So here, probably you will be typing the cost title based on the rules applicable. See, actually in the writ petition prayer or in the affidavit, the first affidavit, when you file a writ petition before this court, it will have the full cause title. The affidavit will have the full cause title. So it will be easy for us to find out who are all the parties appearing before us, whether you have to take notice or not, or somebody will have to take notice, private notice or not. All those we can ascertain. Till assume charge. Then 2 weeks before, I found that cause title are very short. It is going to be full cause title. Otherwise, we do not know which respondent has filed an appeal or whether the writ petitioner has filed an appeal. All those things, we are not in a position to. No, I'm not in a position to file.
There may be some issue, but when we are filing this appeal, Your Lordship, then we are mentioning in the cause title, first of all, this was appealing, and after this, you will see another in the matter of like this, that after in the writ petition, who are the appellant and respondent.
So even the grounds of appeal is very short. You must have the full cause title in the grounds of appeal. So you will be the petitioner, appellant, or you will be the writ petitioner, seventh respondent in the appeal. Somebody else you would have succeeded, the person who got an adverse order would have preferred an appeal. So we must know the status.
This too, it is missing in our.
Otherwise, it will be very confusing.
This
we will not be in a position to pass the orders. So now what I am doing here is, I am mentioning the name of the parties to avoid confusion.
Yes, Your Lordship. If you write in record also this respondent number.
Sorry, please inform, since you are a senior advocate, please inform your friends to give the full cause title in the affidavit and also in the grounds of appeal.
Good.
So it will be easy. If there are any changes to be made, please bring to my attention. So the rules need to be amended. We can say that suitably it can be amended.
I'll inform the learned members of the parts.
Yes.
I leave it.